Fight CPS with numbers. Thursday, July 21, 2011. NOTICE. Filing of criminal charges to County Clerk CO County of blank. From You Can Kiss My Moma Ass. Re. NOTICE. Filing of criminal charges. On the date of blank, you engaged in the criminal activity of taking filed documents and have willfully attempted to conceal these by removing these documents without the consent and approval of the owner, blank, underscore, and failing to return these by submitting to someone other the owner, and this by your own admission. Receipt of this transaction is provided by notarized copy to you. In addition to the filing of criminal charges, your bond insurance information and bond number is required for your indemnity as engaging in actions outside of your oath of office in a criminal capacity. You are to respond with this information immediately and to return all documentation recorded by you as proven by receipt of this transaction. Failure to do so will result in further charges under the Tweel and Carman doctrines for fraud and estoppel to prevent from engagement in future commerce. You are to provide a valid oath of office in determination of this by no later than 10 days from the date of receipt of this letter and by 5 p.m. close of business on that day. To wit, Biffle v. Morden Rubber Indus. Inc., 785 SW2D 143, 144, Text.1990. An instrument is deemed in law filed at the time it is delivered to the clerk, regardless of whether the instrument is file marked. The minute all documents are received, it is recorded. Refusal to record documents once deposited to the county recorder is considered criminal subject to Title 18 U.S.C. Section 2071, and it is punishable by fines and imprisonment without regard to third-party intervention and where consent to third-party intervention is refused by the party recording the document. Title 18 U.S.C. Crimes and Criminal Procedure Part 1. Crimes Chapter 101 Records and Reports Section 2071 Concealment, Removal, or Mutilation generally. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or, with intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing, filed or deposited with any clerk or officer of any court of the United States, or in any public office, or with any judicial or public officer of the United States, shall be fined under this title or imprisoned not more than 3 years, or both. B. Whoever, having the custody of any such record, proceeding, map, book, document, paper, or other thing, willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same, shall be fined under this title or imprisoned not more than 3 years, or both, and shall forfeit his office and be disqualified from holding any office under the United States. As used in this subsection, the term, office, does not include the office held by any person as a retired officer of the Armed Forces of the United States. Revised Statutes of the United States, First Session, 43 Congress 1873-1874. Title LXX. Crimes, Ch. 4. Crimes Against Justice SEC. 5403. Destroying, and circa, public records. Every person who willfully destroys or attempts to destroy, or, with intent to steal or destroy, takes and carries away any record, paper, or proceeding of a court of justice, filed or deposited with any clerk or officer of such court, or any paper, or document, or record filed or deposited in any public office, or with any judicial or public officer, shall, without reference to the value of the record, paper, document, or proceeding so taken, pay a fine of not more than $2,000, or suffer imprisonment, at hard labor, not more than 3 years, or both. See Section 5408, 5411, 5412.1 SEC. 5407. Conspiracy to defeat enforcement of the laws. If 2 or more persons in any state or territory conspire for the purpose of impeding, hindering, obstructing, or defeating, in any manner, the due course of justice in any state or territory, with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing, or attempting to enforce, the right of any person, or class of persons, to the equal protection of the laws, each of such persons shall be punished by a fine of not less than $500 nor more than $5,000, or by imprisonment, with or without hard labor, not less than 6 months nor more than 6 years, or by both such fine and imprisonment. See Section 1977-1991, 20,042,010, 5506-5510.1 SEC. 5408. Destroying record by officer in charge. Every officer, having the custody of any record, document, paper, or proceeding specified in Section 5403, who fraudulently takes away, or withdraws, or destroys any such record, document, paper, or proceeding filed in his office or deposited with him or in his custody, shall pay a fine of not more than $2,000, or suffer imprisonment at hard labor not more than 3 years, or both, and shall, moreover, forfeit his office and be forever afterward disqualified from holding any office under the government of the United States. The oath of office is a quid pro quo contract, U.S. Const. Art. 6, Clauses 2 and 3, Davis v's Lawyers Surety Corporation, 459 SW 2nd. 655, 657, Tex. Civ. App. In which clerks, officials, or officers of the government pledge to perform, support and uphold the United States and state constitutions in return for substance, wages, perks, benefits. Proponents are subjected to the penalties and remedies for breach of contract, conspiracy under Title 28 U.S.C. Sections 241, 242, treason under the Constitution at Article 3, Section 3, and intrinsic fraud as per Auerbach v's. Samuels. 10 Utah 2nd. 152. 349 p. 2nd. 1112, 1114. Allegheny Corp. vs. Kirby. DCNY. 218 F. Sup. 164, 183. And Keaton Packing Company vs. State. 437 SW. 20, 28. Violation Code Section Recommended Penalty Breach of Oath Contract T18 Section 3571, each violation, $250,000 Denial of Proper Warrant T18 Section 3571, each violation, $250,000 No supporting affidavit, no Miranda warning, no damaged complaining party and etc. Denial of Claim of Special Appearance T18 Section 3571, each violation, $250,000 Denial of Reasonable Defense Arguments T18 Section 3571, each violation, $250,000 Denial of Access to All Evidence T18 Section 3571, each violation, $250,000 Denial to Right to Truth in Evidence T18 Section 3571, each violation, $250,000 Attempted Slavery T18 Section 3571, each violation, $250,000 Forced Compliance to Adhesion Contracts Not Held, example requiring a citizen to participate in the Federal Reserve banking system, conversion of the constitutional right to travel to a state privilege, i.e., no driver's license, no auto tag, no compulsory insurance, no inspection sticker, failure to fasten a seat belt, failure to stop for inspection, search without a proper warrant, etc. Converting a constitutional right to AT-18 Section 3571, each violation, $250,000 state-granted privilege with above denial of provision in the Constitution T-18 Section 3571, each violation, $250,000 U.S. and or state. Example. Demanding worthless unbacked printed paper must be coined FRN's payment of state debts. Clerk proceeding with a foreclosure where the filing fee was not paid in lawful money of substance gold or silver coinage in violation of AR 1, Section 10, C1, 1. A federal injunction, treason, combined above Acts T18 Section 3571, each violation, $250,000. Falsifying jurisdiction, trying a common law matter under colorable maritime, trying a state matter under false color of jurisdiction in the U.S. Dist. Court outside the 10 square mile provision at Art. 1, Section 8, CL 17. Attempted genocide T18 Section 1091, each violation, $1,050,000, destroying a family, their way to earn a living while taking their home under color of law and pretended law, misprision of felony T18 Section 4, each violation, $500. Conspiracy, 2 or more people T18 Section 241, each violation, $10,000. Attempted extortion T18 Section 872, each violation, $5,000. Claiming a debt not owed under the U.S. or state constitutions, example, collecting a form of taxes, i.e., property, automobile taxes not authorized by the U.S. Constitution, holding a certified money order and pretending it does not exist, a felony as per U.S. V's Tweel. 550 F2D. 297, 299, 300. Mail fraud and mail threats T18 Section 876, each violation, $5,000. Authority United States Violation Code Section Recommended Penalty Fraud T18 Section 1001, each violation, $5,000. Falsification of documents T18 Section 1001, each violation, $5,000. Perjury T18 Section 1621, each violation, $5,000. Subordinating of perjury T18 Section 1621, each violation, $5,000. Grand theft, see no of counts 18 U.S.C. 2112, T18 Section 3571, each violation, $5,000. Racketeering, civil, T18 Section 1694, each violation, $25,000. Racketeering, criminal, T18 Section 1963, each violation, $250,000. Concealment, removal, mutilation T18 Section 2071, look it up for dollar amount. Failure to produce said documents guarantees the process of due law and your removal from office in addition to statutory penalty, punishment and possible incarceration. This evidence has also been forwarded to the Internal Revenue Service Criminal Investigation Division, along with a copy of the stolen document, as the taxation for the fine in the amount of $blank constitutes perusal by the provost marshals as such. The fines incumbent to the documents filed are in the amount of $blank. Having engaged in the commerce to infringe upon this lawful declaration, Forms 10990 ID will be filed with the Internal Revenue Service to have this fine enforced and to have the Internal Revenue Service require you to pay this by tax. You are duly notified. Sincerely, dated, your name, signature.